Good afternoon, everyone. I hope everyone can hear me okay. My name's Steve Burkill. I'm a partner in the Bangkok office of Watson Farley Williams and the head here of the dispute resolution team. We have an offering for you today and on key strategies for a successful SIAC arbitration, and I'm joined by Marcus Gordon from our Hong Kong office, who's a partner in the dispute resolution team, and Ivy Liu also from our Singapore office. So three of our Asian offices represented today in this preparation, in this presentation. If I may just start with a few words about Watson Farley Williams. We are an international law firm. We are headquartered in London, but we are truly international. We've got 15 offices. We are in 12 countries. We have a growing number of lawyers. We grow year on year. We now number over 500 lawyers. And you can see there we have offices in Singapore, Thailand, Hong Kong, and Vietnam. As a firm, we are sector focused. So rather than being very generalist in our approach, we like to be specialists and experts in particular fields. So we are market leaders in energy, infrastructure, and transport. And within those industry sectors, we provide, particularly in Asia, I would say, an outstanding dispute resolution service, and specifically an excellent international arbitration service. So we work across the major arbitration centers of the world. We do a lot of work with our Asia teams in London and in Paris. And within Asia, we do a lot of work in Singapore, Hong Kong, Thailand, of course, Malaysia, Vietnam, and partnering with Chinese lawyers, we do work in China as well. We are highly regarded for our dispute resolution and international arbitration services. And by way of example, for our arbitration disputes team in Thailand, we have for many years been ranked as the #1 leading law firm for providing international arbitration services, ranked in that way by Chambers Asia Pacific and the Legal 500 directories, which rank law firms according to their expertise in different disciplines. So we wanted to give you a presentation today to impart some of our knowledge and experience of SIAC arbitration. Before I do that, I think Ivy is going to convey something of what I've just said by way of introduction in Chinese before we move forwards with the presentation.
Thank you, Steve. Yes, and 因为首先要谢谢大家抽空参加这个活动，然后群里面很多的朋友我其实都是认识的，然后特别的感激。因为大部分的听众都是中国的朋友，所以的话，在这里的话，我用中文对我们所做一个简单的介绍。然后 Watson Farley Williams 的话，我们其实有一个中文的名字叫做华盛律师事务所。然后我们是1982年在伦敦成立的一个国际性的律师事务所。目前的话，我们在这个12个国家有15个办公室，目前有500多名律师。目前在亚洲的话，我们有4个办公室，包括新加坡、泰国、越南和香港。 新加坡的办公室是1998年就成立了，然后泰国是2001年 ，Hong Kong 和Vietnam 就是越南的话，分别是2012年和2019年。我们是一个专业化程度比较高的律师事务所，然后我们主要的这个专长呢是在于这个能源、基建和交通行业。当然，我们在这些领域的话，也是一个 full service 的一个 practice。 就不光光是做 corporate 业务、非讼的业务，我们也可以做这个诉讼业务，提供争端解决的这个服务。特别是在争端解决，然后国际仲裁方面的话，我们非常有经验。像这个 Steve 和 Marcus 的话，都有20多年以上的经验。特别是泰国的办公室，在2012年就在过去的10几年，我们一直在这个钱博士上面的排名是 Band 1。所以这次的话，我有幸邀请这个 Marcus 和 Steve， 就这个根据他们的经验，就这个新加坡国际仲裁提供一些这个分享做一些分享，然后希望对大家有帮助。如果后续大家有问题的话，可以在这个演讲的这个结束之后提供一些提一些问题，然后我们不管是可以用中文也可以用英文，然后我们可以去尽量做解答。谢谢大家。Back to you, Steve and Marcus.
Okay, I just before we start, a few housekeeping points. For the purposes of this presentation, if we could ask everyone to please mute your microphones and turn off cameras through the presentation so that the presentation proceeds smoothly. And also, as we go along with the presentation, I understand there is a chat box available, and you will be able to frame and send in any questions that you would like to raise as we progress with the presentation. And then at the end, we will leave some time to go through any questions that you have raised. If you would like to raise some questions at the end, please feel free to do that. And between the three of us, we will do our level best to try and answer any questions that you have. Separately, if anything that we have to say raises interest for you and you would like to approach us separately outside of this presentation today, please do take full advantage of our services, and we will do our level best to engage with you by emails or on separate telecoms if that would be of assistance to you. So let me move forward with a first introduction of the issues that we will look to present to you on today. There is, first of all, we're going to have a presentation on why arbitration. So why would we look at arbitration rather than court? What are the pros and cons? Secondly, we're going to look at why SIAC. Why would we suggest to you going to a Singapore International Arbitration Centre for arbitration? Why is that a good forum for dispute resolution in our experience? We'll look to recount some of our experiences. We thought it would be appropriate also, thirdly, to address you on choice of legal counsel. Of course, we would say you need not look no further than Watson Farley Williams for that service, but we will endeavour to elaborate on some of the things that you should take account of and consider when you are choosing legal counsel. We'll talk a little bit about fee structures of legal counsel, because I know from experience, clients will often ask about working on contingency basis or discounted rates or some element of success fee. So I wanted to, for our presentation, to include something in that area. And And a natural development on from that point is the next point. We wanted to talk to you today about litigation funding, because depending upon the kind of dispute that you may have and where you have that dispute, and who you are against and the merits of your case, it may be possible for you to get a third-party funder to pick up the entire cost of your litigation, arbitration, so that they take the financial risk for you and you don't have to be paying for the litigation that you bring. We're going to be talking about choice of the tribunal. In my view, probably the most important decision, or, other than choice of legal counsel, choice of tribunal will be the most important decision that you make, because the way in which your arbitration proceeds is very much dependent upon the arbitrators that are put in place at the outset. And they're going to be very important for you in terms of the speed of the process, the kind of submissions that they will allow, the evidence that will be allowed to emerge, whether there is a hearing or not, and how that hearing should be conducted, and so on. We thought it was very important also to talk to you a little bit about interim and conservatory measures available to a tribunal and or the court, because we are often acting for claimant clients who have concerns that the respondents, defendants they're acting against are going to take steps to make themselves award proof. In other words, they're going to be emptying their bank accounts, moving away assets, in the knowledge that when they lose, or we win, then you won't be able to do anything with the award. You will end up with a paper award. And as we will explain to you, there are certain interim conservatory measures that we can apply to a tribunal and a court to get to help you with this. We'll also talk a little bit about rights of access to information and documents in the possession of the other side. So again, from our experience with clients, they will often say to us, they believe that they have a particular issue that they're going to have difficulty proving, but they know that the other side has documents or evidence of some kind which would support the point that they want to convey to a tribunal. And again, there are ways and means and orders that a tribunal can be asked to make to get access to that kind of crucial information to help you establish your case. We're going to talk a little bit about identifying assets and locations. We're going to talk a bit about injuncting funds or assets and how you would go about doing that. And something that's quite topical for us, SIAC has some excellent emergency arbitration procedures and some fast-track arbitration procedures, which is often of interest to clients. One of the big concerns of clients in our experience is that litigation moves too slowly. And Singapore, as a matter of government policy, wants to drive forward its international arbitration processes. It wants them to be the leading arbitration processes in the world. And in order to acknowledge client concerns about the speed of arbitration, it has implemented some excellent rules in the SIAC arbitration procedure relating to emergency arbitrators and their appointment, and to fast-track arbitration. So we can talk a little bit about that as well today, which hopefully will be of interest. So those are the points we're going to cover. I think Marcus is going to get us going with the why arbitration and why SIAC.
Thanks, Steve. When I joined Watson Farley in 1999, I was in the London office, and I was a junior lawyer, very interested in getting involved in some shipping disputes, which was going to be very new for me. After I had been in the office for just a couple of weeks, my boss came into the office and told me that a partner in Singapore needed some help with one of his cases. That partner was Steve Burkill, and could I go over to help him? I jumped at the chance and said, well, yeah, of course I'd like to go to Singapore to help with his case. When will I be leaving? And I was told that I'd be leaving that very evening, and that I didn't have time to do anything else. I just had to go home, pack my things, and the documents would meet me at the airport. So that was my introduction to arbitration in Singapore, and that was my introduction to Steve. I suppose the fact that I'm still in the region over 20 years later itself says how much I think about Singapore and arbitration generally, because after my arrival in Singapore, although I was only supposed to be there for 3 weeks, I stayed there for 18 years, and it's been just a couple of years that I've been in Hong Kong. But I would still say probably around 70% of my arbitration work is Singapore-based arbitration. So the first question that arises is, why would you choose arbitration? Disputes are the last things that people are thinking about when they are negotiating contracts. I think this is one of the reasons why the dispute resolution provisions are frequently at the end of the contract. But even though it's at the end of the contract, it is extremely important and should be given some serious thought when the contract is being negotiated, so that you have some control over how disputes are resolved if things do go wrong. One of the most valued aspects of arbitration is the fact that it is private and confidential. Litigation is public, it's in the court, all of the papers submitted in the proceedings are public and in the court. So effectively in litigation, the parties have to sort out their disputes and have their secrets revealed, all in the open. And it's quite rare that parties are able to maintain an adequate level of confidentiality and privacy in litigation. So if you have things that you want to keep secret, or if you want to keep any disputes private and between you and your contracting counterpart, then arbitration is the way for you to go. Arbitration is also very, very flexible. You can determine the rules that you wish to apply, the procedures that will be applicable, how long you are going to have to do certain things, so the timetable, and one of the most important things, as Steve mentioned earlier, is your ability to choose your tribunal. With a court system, you don't have really much choice at all. So, for example, if you have a shipping dispute in the courts, unless you're in a jurisdiction that has a specialized division, then you are going to have a judge who doesn't necessarily know anything about shipping law. So, for example, recently, I had a case which is actually still ongoing, but I had a case in the Cayman Islands, and the case went to its hearing, and the hearing went very well. And then we thought the judge had understood everything. The judge was nodding at all of the right times. But then when we got the judgment, it was very clear that the judge had not understood the case at all. She was not a specialized oil and gas person, and this was an oil and gas dispute. In her judgment, she had made some fairly fundamental errors, and she had completely missed many of the important factual and technical points. And that's simply because she was a criminal judge, and she didn't understand the technical aspects of the case. Fortunately, as is the case with most court procedures, there is a right of appeal, and the judges in the appeal do tend to be more specialized in high value commercial disputes. So that particular case, we are going to the Court of Appeal, and we fully expect to do much better than in the court below. But that's just an illustration of how important it can be to have a specialized tribunal. So, for example, when a client comes to me, one of the first things that they will ask is, can we choose a friendly arbitrator, one who's going to make a decision that we want them to make. Unfortunately, that's not possible. Arbitrators must be impartial and independent, and merely choosing an arbitrator won't necessarily mean that he or she will come up with a decision to favour the party that's appointing him. However, what we can do, we can advise on the best arbitrators to choose for your particular case. So, for example, if it is a complicated construction dispute or a shipping dispute, then we know the arbitrators who are best able to deal with those types of disputes. Also, many of the arbitrators we have been in front of before, or we have read their articles, so we actually know their opinions. There are some arbitrators who have certain opinions where they've written articles expressing those opinions and those views, which might give an indication as to which way they might go in the event a certain type of arbitration comes before them. So that type of industry insight and knowledge can go a very long way. So for example, the panel of arbitrators who were sitting on that arbitration that brought me over to Singapore to first work with Steve, I still appoint those arbitrators because we know their style, we know how they deal with matters, we have a good working relationship with them, and whilst our relationship cannot impact on their legal judgment, it can help us to tailor evidence and tailor approaches to make sure it's not the evidence isn't presented in a way that they might find objectionable. Also, we will know the types of cases they're familiar with. So the witness statements can be drafted in a certain way with a certain assumption of knowledge of technical ability, which you wouldn't have if you didn't know the arbitrator, for example. Another huge advantage of arbitration is the fact of enforceability. With court proceedings, whether you can enforce a court judgment from one country in another country will very much be dependent on whether or not those two countries have a treaty between them. And the process of recognition and enforcement between countries can be very long and protracted if there is one at all. However, with arbitration, an arbitration award in one country who has signed the New York Convention is enforceable in another country who has signed the New York Convention. Currently, there are 164 countries that are signatories to the New York Convention, and another 40 countries who have extended the application of the New York Convention to them. So essentially there are over 200 signatory countries. I would say that every industrialized major country is a signatory to the New York Convention, every trading nation. There are a few exceptions. The ones that spring to mind are North Korea, and there are a few countries in the Middle East and Africa. So if you're doing business there, it's probably best to check whether or not they're signatories to the New York Convention. But by and large, most trading nations, industrialized nations, are signatories, and it makes the judgment that you get in your hand, the arbitration award, much more useful than if you have a mere judgment in the country, in which case it may well not be worth the paper it's written on. The next question is why the SIAC? When I first got to Singapore, the SIAC hadn't been invented, and we were fighting our arbitration under the ICC rules, the International Chamber of Commerce rules. And in Singapore, the arbitration law hadn't developed as well as it has to date, but the government had a vision that it wanted to make arbitration in Singapore better, to attract people there. So it implemented the SIAC. The big difference between institutional arbitration, such as the SIAC and the ICC, and what you call ad hoc, is that with institutional arbitrations, you actually have a body, a supervising body, who governs what happens during the arbitration. With ad hoc arbitrations, you have the arbitrators who run the procedure, but if anything goes wrong with the process, then you must go to the courts of that country, by and large, to obtain rectification or to get satisfaction, which can often take a very long time and can often be very expensive and unpredictable. But the good thing about the SIAC is that they are very hands-on and they manage the arbitrators. So, for example, the SIAC will take a very proactive role, making sure that arbitrators stick to deadlines. I have heard stories, for example, of arbitrators taking 10 years to write an award. And that arbitrator, obviously by the time you get to 10 years, he had no intention of writing the award, but they couldn't do anything about it. Whereas the SIAC, they are very hands-on, and they move the arbitrators along, and they manage the procedure and they manage the timetable in a very, very rigorous manner. I've actually been arbitrator in SIAC arbitrations on a number of occasions, and the person running the file will frequently email the parties and the arbitrator to find out what the status is, and to seek updates to make sure things are moving along quickly. One of the advantages of institutional arbitration is that they have fixed fees. So you have an element of predictability about the cost of the arbitration before you even start. The fees of the arbitrators are dependent on the size of the claim. So if you have a very large claim, then the arbitrators are entitled to charge higher fees. For very small claims, the fees are lower. With the SIAC, the fees are similar to ICC fees, but one advantage is they are cut up into 3 slices. So you don't have to pay all of the fees up front as you do with the ICC, but you pay a proportion at the beginning, a proportion further along, and a proportion when you set down for a hearing. Another very good feature of institutional arbitrations, and especially the SIAC, is the fact that they conduct a due diligence on the arbitrators on an ongoing basis. This means that the arbitrators on the SIAC panel are reputable and reliable, and their information and experience is up to date. Not only are they motivated to work quickly, because the SIAC keeps an ongoing record of how quickly they react and how happy the users of the SIAC are, but they will remove arbitrators for improper behaviour. And I suppose that is an appropriate time for me to refer to the entry on the slide, challenge of arbitrators. So if you have an arbitrator that has been appointed and that arbitrator behaves in a manner that you consider to be inappropriate, it is possible for you to apply to the SIAC to have that arbitrator removed. The procedure is efficient and it's fast. I know this from bitter experience, as a party once applied to have me removed as the arbitrator when I did some things that that party didn't want me to do. In actual fact, the party who sought to have me removed had not been conducting themselves very quickly in the arbitration, and on the day of the trial, so the first day of the trial, we were all sitting in the room for the first day of the trial, and they asked for an extension of time and an adjournment of the trial for what appeared to be spurious reasons. And when I refused to grant the extension, they said they were going to challenge me unless I changed my mind. So I said, well, I suppose you best challenge me. And they challenged me and tried to have me removed. But the trial went ahead. The SIAC investigated the matter. They found that there had been no improper conduct, and I remained, and the arbitration award was enforced. And that brings us neatly into the final point of this slide, and that's enforcement of awards. In some jurisdictions, institutional arbitration awards are enforceable, whereas ad hoc arbitration awards are not enforceable. So depending on where you are likely to be enforcing any arbitration award, this may be a very significant factor. However, at the outset, you should be aware that if it is an institutional arbitration, then it will be at least as enforceable as an ad hoc arbitration. And with that, I will pass over to Steve.
Thank you, Marcus. Okay, I was going to say a few words about choice of legal counsel, and I would suggest that for international arbitration, for SIAC arbitration, you need legal counsel with an appropriate specialism. You need lawyers who have had several years working in the arbitration field, who know their way around the rules, who know the arbitrators who are to be engaged and who are engaged, and the way in which they would like their arbitration to be conducted. Arbitration and conducting an arbitration truly is a specialism. And what I can say from experience is that that is a specialism for us. It represents in this office in Thailand about 70% of the business that we do. And we have among our team of arbitration specialists, there are 3 lawyers who regularly sit as arbitrators, and specifically as SIAC arbitrators. So we very much know how arbitration and SIAC arbitration works. What I would also say is we frequently encounter for our clients parties on the other side who are not represented by legal counsel with arbitration and SIAC arbitration specialism. And it becomes very plain very quickly that their client is disadvantaged by that. And it's very much to our advantage. For perfectly clear reasons, they don't know how to select an appropriate arbitrator for the dispute. They don't know their way around the rules and can't take advantage of opportunities that are available to them within those rules to accelerate or slow down the process or secure the kind of discovery of evidence that they might want. And in particular, what we see is they just do not know how to present well before an international panel of arbitrators. It appears that they have capability of providing an advocacy service in their courts, but advocating before a panel of arbitrators in an international arbitration is very different. And I suggest it's absolutely critical that a good choice of legal counsel is made at the very outset. I'd also say that when you're choosing legal counsel, not only do they need to be particularly able in arbitration and SIAC arbitration, but it is a big advantage if they have industry knowledge. And that may be surprising for clients to hear, because they assume that the lawyers that they engage just need to be capable of marshalling legal arguments and presenting them in an ordered way to try and persuade somebody who's deciding the matter before them, and that would be all. But that is not correct in our view at all. And for example, we as a law firm have a strong specialism in renewable energy. So we have done a lot of power plant dispute work, and we have acquired over the years excellent technical expertise in that sector, to the point where we have represented clients in power boiler disputes, power plant arbitrations, and we have demonstrated to the client a technical understanding which is almost the equivalent of their own expertise. So we've been helping them develop arguments that they hadn't even thought about. So I really would suggest that industry knowledge is critical. I just want to convey this point with as much force as possible. We are often in the arena of having to persuade potential clients to instructors. And if we were approached in this office to do capital markets work, for example, I would be hesitant, because I know that we can do that kind of work, but it is not a true specialism of ours. When it comes to arbitration, international arbitration, it is absolutely a specialism of ours. For myself, this is what I've spent 25 years plus doing. It's almost all that I do. It can be quite frustrating trying to persuade potential new clients to use our services as against other law firms who we know are being approached, who just don't operate in arbitration at all, let alone have knowledge of SIAC arbitration or industry specialism. So I would urge clients to take that point on board and take it seriously. Your choice of legal counsel is absolutely critical to the way in which your case will progress and your chances of success. Fee structures. Let me say a few words about fee structures, because again, when we're approached by potential clients, having got through the pleasantries of introductions, it's almost the next question that's asked: how much is this going to cost me? To which the answer is almost invariably, we don't really know, because it depends upon so many variables that we cannot always control. In particular, it depends upon the counsel that is put in place, the kind of arbitration they want to see conducted, fast, slow, medium paced. It depends upon the behavior of the other side. So, and they can speed things up or slow things down. So fee structures are not always difficult to set at the very outset, but what I can say is this. It is possible to come to an arrangement with a law firm, certainly a law firm like ours, where there is a part contingency with legal fees. Wholly contingent arrangement simply is not possible. Law firms, international law firms, English law firms are not allowed to operate in that way. So you should be concerned if any law firm is saying to you that they can work like that, because if they do so, they're probably operating illegally. We, for our part, will go partly contingent on fees where clients ask us to do so, where we have a measure of confidence in the case. And in that way, we are aligned with a client to try and do everything we can to succeed, and for the client to believe in us and see that we believe in the case and we have something riding on the outcome. We have some of our own fees depending upon the outcome. The other thing to say, I think, is you should remember that fees in arbitration, certainly in SIAC arbitration, are recoverable. Therefore, when your case goes forward and goes to award, if you're successful, you can have an expectation that you will be awarded a reasonable proportion, probably 70% or more, of the fees of the law firm that you have engaged, provided that law firm has behaved well. And you would also expect to recover most of the disbursements. For years, for many years, we had potential clients coming into our law firm who were asking us if we could act on a wholly contingent basis, and the answer was no, and it remains no. However, there's been serious developments in this area with litigation funding from third parties becoming the new game in town over the last few years. And this third-party litigation funding is excellent news for many clients who may otherwise not have the financial ability to take claims forward to conclusion. So we may look at a case with a client and advise them that if they're going to take their case through a SIAC arbitration, they may have to prepare themselves to spend $1 or $2 million even for a bigger case. And often that is met with great concern by the client, who said, I simply can't take it forward. I don't have the financial ability to pay that. And they historically were simply settling on unreasonable terms or not even pursuing their claim at all. Litigation funders have changed that environment. Third-party litigation funding is very much available for arbitrations in some key places in the world. It's available in the UK, Australia, the US, and now in Asia. Thankfully, it's available in Singapore for Singapore arbitrations and in Hong Kong for Hong Kong arbitrations. So as a matter of Singapore law, since 2017, you can conduct an arbitration, a SIAC arbitration if you like, that can be funded completely by a third-party litigation funder. Historically, that wasn't possible. It is now. Let me just say a few things about litigation funding, because this is, as I say, such good news for clients potentially who may otherwise not be able to take forward their case. So what it means is that if a funder likes your case and can agree commercial terms with you, they will pay all of the costs of your conducting your litigation arbitration. You won't have to pay anything. They will pay everything. It's non-recourse funding, which means that the funder takes the risk. So they look at the case, they decide that they like it, they agree to fund your case, and if the case is lost, it's money lost by the fund. There is no loss to you, the client. It's simply lost by the funder. That is the price. That is the risk that they take. Of course, funders are not doing this out of the goodness of their heart. It's a business for them. They want a good commercial return for the investment that they make, and a fairly typical return that I've seen in my experience. And more than half of the cases that we conduct today from this office are funded by third-party litigation funders. Typically, the typical return is 2 times the investment. So if an arbitration costs $1 million, let's say, the funder would expect to receive back its $1 million and another $2 million on top. Alternatively, it may say, I'll take as my return a percentage of the overall win. So you may take your case forward to conclusion, have an award for $10 million, and there may be an arrangement in place with a funder where they take 25% of your winnings. So with a $10 million success, they would take perhaps 2.5 million. And just to make the point also that this is litigation funders fund not a paper award, they're funding securing the award and collecting the money as well. So provided that you can agree commercial terms that you can live with, litigation funding is very, very good news for clients, in my view. It takes away the risk. I would encourage clients to give that some serious consideration. Of course, if you there is always a risk if you lose an arbitration or piece of litigation, that you will have to be ready to bear the costs of the other side, which is a risk in litigation. And thankfully, there is even a solution for that with litigation funding as well, because litigation funders can, on request, agree to look into placing and paying for something called after the event insurance. And the effect of that is that if you bring your case forward and lose, under the terms of the after event insurance, the costs of the other side are met by the insurer. So you have had all of your risk covered. Now, for litigation funders, this is a business for them, so they won't fund every case that is presented to them. They will only fund cases which meet the criteria which they set. So the case has to be good on its merits. The defendant has to have the means to pay. There has to be a good dispute resolution mechanism in place. So if they saw a good case, but it was to go forward in the court of Indonesia or courts in Africa or somewhere in the Middle East, almost certainly they would say, we're not interested in funding that because we don't trust that dispute resolution mechanism. Arbitration, by and large, they trust. Arbitration in SIAC, they absolutely trust and would happily fund the SIAC arbitration if it met other criteria. And of course, they have to agree with a budget for the case, make sure that the budget makes sense. So if you have a $100 million claim and you need to spend $2 million on the case, of course it makes perfect sense. If it's a $2 million claim, but you have to spend $1 million to get to the end, it's starting to look borderline as to whether it makes financial sense. If it costs $1.5 million to bring the case, it probably isn't going to make sense. The other critical factor is that litigation funders will only fund law firms that they trust. So they will not agree to choose lawyers on price. They won't agree to cheap arrangements. They want to choose lawyers with a good reputation for conducting arbitration and who they believe will increase their prospects of winning. So that is another feature of litigation funding to bring to your attention. I think we're moving on to choice of tribunal. Mindful of time, let me try and move through this quickly. In most dispute resolution clauses in contracts, there will be provision made for how a tribunal is to be constituted. It will often state the number of arbitrators, usually 1 or 3, and it will provide for the mechanism by which they are appointed. Typically, if it's a sole arbitrator and the parties can't agree with SIAC, the registrar of SIAC would make the choice. If it's a 3-man tribunal, usually each party will choose an arbitrator, and the 2 arbitrators so appointed will choose a chairman. Under SIAC rules, if the dispute resolution clause is silent on that, then the registrar of SIAC will make the choice. Choice of tribunal, as Marcus was saying, is very important. It's absolutely critical to get your tribunal right, to make the right choice. And again, inexperienced lawyers, lawyers not experienced in arbitration, SIAC arbitration in specific industry sectors will make bad choices. It's important to make good choices. If you have a dispute in the renewable energy sector, it's very important that you choose arbitrators who are knowledgeable about renewable energy projects and disputes, and we would help in that area. We know exactly who those arbitrators are. In construction disputes, generally, we know those arbitrators. In shipping arbitrations, we know who those arbitrators are. It's also important to have regard for the way in which you think the other side are going to behave. So sometimes we will be on the opposite side to law firms who behave well and are professional, and that will influence our choice of arbitrator. Sometimes we will be on the opposite side to an opposing party and a counsel who behave very badly and are looking to delay, to argue about everything, to make as much, put in place as many obstacles as possible. And you need to make sure you've got a firm panel of arbitrators who will not tolerate that kind of behavior and will deal with it firmly. And again, some arbitrators have a good reputation for dealing with that well, and some have a poor reputation. And again, choice of arbitrator is critical. Some are very busy and are slow. Some are less. So it's, again, in terms of choice of arbitrators, it's important to make sure that you choose arbitrators who are going to have the time that is required. There are adequate provisions in SIAC rules for challenging arbitrators. Marcus talked about that a little earlier. So in circumstances where you are concerned about the choice of arbitrator that the other side has made, for example, there are mechanisms in there for challenging that and having them removed, replaced, if that's appropriate. We should move on. Tribunal interim measures. Marcus, I think.
Yes.
Are you going to speak on this one, or am I? I think this one is mine as well, isn't it?
Yeah, you were going to speak on this and I was going to make some comments.
Okay. Well, briefly, we thought that this was important to convey some messages about the interim measures, the powers that a tribunal has once you have an arbitration ongoing, because clients are frequently concerned about assets disappearing, about the awards being made award proof, so that you succeed in the arbitration, you get an award in place, but then there is no bank account to attach when the other side refuses to pay, or there's no property or asset to get hold of and sell, to make sure that you achieve a recovery on the award. And again, SIAC rules are very helpful in this area. A tribunal has power, I refer to section 30.1 of SIAC rules, they have power to grant an injunction where it's appropriate. And there are lots of provisions under SIAC rules for arbitrators to exercise a discretion and order interim relief as the arbitration is progressing. So along the way, the tribunal on request can make orders to freeze bank accounts if you can show a tribunal that there's a real risk of bank accounts being deliberately emptied to make the award proof. You can look to secure moreover injunctions over assets as well. So again, freezing assets and so on. You can get from a tribunal Anton Pillar orders, so you can get orders whereby you can go into the opposing parties' offices to secure documents that you consider would be important to get hold of. There are all kinds of remedies that are available to you through the arbitrator, and arbitrators in Singapore under SIAC rules, if they can be persuaded, are ready to make the orders that will assist you. So again, they can order that witnesses are made available, they can order production of documents, and where they make orders which are not complied with, those orders of the tribunal can be presented to the Singapore court, and the Singapore court will be highly supportive of those orders handed down by the tribunal. Marcus, I think the next slide is yours.
Yeah. One of the biggest stages in any arbitration is the exchange of evidence stage, and it's important for the tribunal to have the power to order that documents are disclosed. It's also important for the parties to be aware of the powers that the tribunal has and the traditions that they adopt. And these can be very, very different from country to country. So a lawyer from a civil jurisdiction might be very unfamiliar with the normal rules of documentary disclosure that are very, very familiar to someone from a common law jurisdiction. And tribunals under the SIAC, whilst there are tribunals from civil and common law jurisdictions, the SIAC rules accommodate that very well. The tribunal has the power to direct disclosure of documents, as Steve said. They can order witnesses to disclose documents, and the Singapore courts are very supportive of this, and they have passed legislation to make this easier. So, for example, many years ago, I recall in one arbitration hearing, there was the lead witness for the opponent who was giving evidence under cross-examination, and he referred to some diaries that he kept, and we asked him where those diaries were, to which he responded, they're in Finland. And when we said, well, will you produce them for the tribunal? He said no. So we had to go to the court in Singapore to get a direction. Then we had to go to the court in this person's home country to get an order of the court. There was a long, protracted argument through the courts, and in the end we got the documents. Now the procedures have been very much refined, such that we would expect nowadays the tribunal to itself be able to direct the respondent to be more responsive, failing which there may be sanctions which apply. The tribunal has the power to not only order disclosure of documents in the form of emails, letters, etc., but it can also order disclosure of any type of recording or any format in which information, relevant information, is contained. And arbitral tribunals do tend to be much more flexible in the way documents can be exchanged. Court procedures are frequently quite rigorous and inflexible, whereas tribunals will allow the presentation of evidence in a much more convenient and user-friendly way. I'm aware of time passing, so I won't dwell on this too long, but I'll pass over to Steve to discuss emergency arbitrators.
Yes, one of the more recent developments under SIAC rules has been the development of an emergency arbitration procedure. So how does this work, and what's the process and the cost, and what orders can be made? When a party wants to bring arbitration, they typically, in a SIAC arbitration, will prepare something called a notice of arbitration, which sets out certain key parts of their claim, refers to the dispute resolution clause, perhaps adduces a few documents in support to get the process underway. And then a response comes 15 days later, and the tribunal is constituted usually within a month or so, and then the arbitration proper starts to unfold. In certain circumstances, there will be companies, clients, who come to you and say, I need to bring my claim in arbitration, but there is an emergency. Something extraordinary is going to happen in a short period of time, which we really have got to try to stop, because it's going to jeopardize the arbitration, jeopardize the purpose for which the arbitration has been commenced. So, for example, it may be that the only asset of the defendant is being moved from the jurisdiction, or it has become clear that the respondent is deliberately emptying its bank accounts and moving money to a jurisdiction where the monies can't be secured. Where you're faced with that reality, there is something you can do under SIAC rules. At the time that you serve the notice of arbitration, you can also apply to the registrar of SIAC for an emergency arbitrator to be appointed. What you have to do is explain the relief that you're seeking, explain the reasons why you want the relief, and you've got to inform the other side of the application. Within a day, SIAC will decide whether your application has merit. Usually they err on the side of caution and agree that it does, and they will appoint an emergency arbitrator within a day. And the emergency arbitrator will act upon the application before it. It will set a schedule within no more than 2 days, and it will make a decision or orders within no more than 14 days. Within the past month, we have been involved in an emergency arbitration procedure where those timelines were rigorously followed. SIAC appointed an emergency arbitrator on an application where there were concerns about a particular construction dispute. There were concerns that a particular expert determination process was unfolding in an unsatisfactory way. And there were concerns that bank bonds were going to be called down upon quite wrongly. And therefore, an application was made to SIAC. The registrar appointed an arbitrator, an emergency arbitrator, within less than a day. That arbitrator set a very short timetable and made a determination on the written exchanges of the parties without a hearing, and made some orders in relation to that application. So there is a fabulous, fast emergency arbitration procedure available under SIAC rules these days. Marcus, fast track arbitration.
And I'll make this a fast track slide as well. Fast track arbitration is basically a procedure whereby all of the timetabling for an arbitration from the appointment of the tribunal right up until the delivery of the award is done in under 6 months. Normally an arbitration would take between a year and say a year and a half in a fairly complicated matter, and the arbitration award may take between 2 to 6 months. But in fast track arbitration, the arbitrator at the time of appointment is aware of the fact that he must deliver his award within 6 months of his appointment. So you can bet your money that the arbitrator is going to move things along very quickly. I have been arbitrator in several fast track arbitrations, and during one of them, I was chairing the directions hearing, which is the first meeting of the parties where you discuss the timetable for the disclosure of evidence, the exchange of witness statements and expert reports, and you set an agreed timetable for them. So during this discussion, the parties had come in with an agreed timetable that they would exchange their written arguments, the initial written arguments called pleadings, within a certain amount of time, and then they would disclose their documents within another amount of time, etc. And I looked at the timetable and said, well, do you realize that I'm going to have to write my award within 6 months of this meeting? And I said, well, I suggest you step outside for a little while and agree a different timetable, because I want 3 months to write my award, which means I'm setting a hearing date for 3 months' time. And you are going to have to fit your evidence into that. So they went outside, then came back in, and they were able to comply with the timetable. Needless to say, we never got to a trial on that case because the parties agreed to settle. Because of the tight timetable, they didn't have any time to waste. It forced the parties to really consider their cases and whether or not they really wanted to fight it according to the tight timetable that they themselves had agreed. In actual fact, in that case, I think one of the parties didn't really have a very strong case, and the fact that he was fighting the arbitration was a time-wasting strategy. But because it was a fast-track arbitration, that option was lost. Fast-track arbitration isn't necessarily available to everybody. Normally, it's for cases that are worth less than 6 million Singapore dollars. However, what you can do in advance of a dispute arising is agree the fast-track procedure, so then it will apply automatically. Finally, with the awards don't have to be as detailed in fast-track arbitration. For any arbitrator, writing an award can be the most time-consuming part of all, because he has to go through all of the evidence, all of the hearing transcripts, all of the witness statements, all of the expert reports, and produce a fully reasoned award. That takes a lot of time and costs a lot of money. In a fast-track arbitration, the arbitrator can write an abridged version of the award. And I think that is everything. So unless Steve has anything to add.
No, I don't think so. I am aware that we run right up against the clock, but we do have a bit of time left. There's an opportunity to ask some questions now, if we can help anyone with any particular inquiries that they may have.
Hi, Steve. Actually, I received a question privately to me, but of course, I cannot answer that. I will need your input. And so the question is about if either contracting party is in Singapore and they are in different countries. And so in this case, what's the difference and what's the pros and cons of choosing SIAC and other arbitration tribunal? And when drafting the relevant contract, there's anything the other party, both parties should be aware of, should be paying much attention to. And also after arbitration, for example, if the arbitration is going to be enforced in Vietnam, what will be the challenge in terms of enforcement?
Okay, well, in terms of parties who are not actually based in Singapore, that does not preclude them at all from agreeing that they would have their dispute decided by arbitration in Singapore. For me, many clients that we have who are conducting projects in Thailand or Indonesia or Vietnam with Thai or Indonesian or Vietnamese companies agree that they will have their dispute decided by arbitration in Singapore. So that's not unusual at all. And they do that for the very good reason that Singapore arbitration, SIAC arbitration, is a good, reliable dispute resolution process. And it's known to be independent and impartial and really valuable in this region where you may be a Chinese contractor providing services into a project in Thailand. And the Thai company may be saying to you, let's agree that we have our dispute be decided by arbitration in Thailand or in the courts in Thailand. And understandably, the Chinese company would say, I don't really like that idea. I'm a bit worried that if we get into a dispute, Thai courts will favour the Thai party. How about we have it in China? And of course, the Thai company will say, well, I don't really like the idea of having my dispute decided in the Chinese courts. So Singapore is a fantastic compromise, and it is absolutely fair and independent and impartial. Having produced the award, there will be a winner and a loser, no doubt. And if the losing party is in a country like Vietnam, then Vietnam is a country that is a signatory to the New York Convention. You can take your award to lawyers in that country. We have a Vietnam office. We can help register that award in the courts in Vietnam and enforce that award in Vietnam. As Marcus said, there's a long list of countries who are signatories to the New York Convention. The practical reality is that some of those countries' courts do enforce the awards and do so properly. Some do so, but they're a bit slower than they should be, but you get there in the end. And then there are some countries who are signatories to the New York Convention who actually don't enforce the awards in their countries. So it's case-by-case basis, and we can give some good practical advice on the position. And the client would be quite right up front. This is a key question. Where is the defendant? You know, we may decide the client has a good case, but then the question is, can the defendant pay? And if we fear that they will not pay, where do we have to go to collect the money? And if we're collecting the money in some countries, absolutely fine. There are some countries where we would say that is going to be a problem to go and collect on that award in that country. And we need to give good objective advice of that from the beginning.
Yeah, I would condone everything Steve said there. I would just add a couple of practical points. As Singapore being the place where you actually have the arbitration, the infrastructure in Singapore for looking after parties that are arbitrating is, I think, without a doubt, the best in the world. You have a designated place, Maxwell Chambers, where the arbitration can take place. And that's a state-of-the-art centre with numerous hearing rooms, with transcription services that are available, located near the city centre. It's easily available. Also, another area of potential concern is getting a work permit so that people can travel into and out of Singapore. The arbitrators might not be from Singapore. The lawyers might not be from Singapore. Same with the individuals. Singapore actually has a very liberal carve-out for arbitration, such that you don't need to get a work permit if you are in Singapore for the purposes of an arbitration. And that used to be a problem, but it's not a problem now.
I think there's another question that's come in about whether we have ever succeeded in enforcing a SIAC award in Thailand or the Philippines. And the answer to that is, well, certainly in Thailand on multiple occasions. 10 years ago, Thailand would have been regarded as one of those countries which was a signatory to the New York Convention, but the courts were slow to take an award through the courts and enforce it. That has changed dramatically. Thailand is now a country that will recognize an arbitration award, certainly a SIAC arbitration award. They will allow objections to be taken to the award. They will hear the arguments, and Thai companies against whom an award is being enforced will, as a matter of course, begin to raise arguments about public policy, the fact that a tribunal wasn't fairly constituted, or the hearing wasn't conducted in a fair way. The Thai court will hear those arguments, but they will, in our experience, do the right thing and dismiss those arguments and award enforce the award. They will do better than recognizing the award. There are mechanisms to allow you to go and attach assets, get into bank accounts to get an award paid, and they even have tracing procedures there that we have tested and which work, where respondents who don't want to pay the award start to move away their assets to other individuals or other companies to try and make themselves award or judgment proof. The court will bring those assets back to allow you to collect. Of course, there's a process to go through, but it's possible. So Thailand is good these days. Philippines, I have no personal direct experience of enforcing the awards in the Philippines. My suspicion is it has improved, but I suspect it is not as far along the road as Thailand is, and will be nowhere near as good as jurisdictions like Singapore or Hong Kong, but will be better than Indonesia.
Yeah, I've had 4 arbitrations against, well, it was actually 4 simultaneous arbitrations against a shipyard in the Philippines, representing a Chinese owner, and we were successful in the arbitrations, and the yard, which was actually an international listed company, so it may be that that was at play as much as the enforceability of the award in the Philippines itself, but they ended paying up. So that's the closest I've got to having to enforce awards in the Philippines. They paid, but I don't actually have experience of somebody trying not to pay on an award in the Philippines.
That's good to know.
Yeah, I don't know if that's a good thing or a bad thing.
Well, I don't believe we have any more questions coming through the chat box. So I think we're probably out of time. So just on behalf of the 3 of us, to thank everyone for joining and listening in on this presentation today, and again to say, there is so much to talk about when it comes to SIAC or arbitration. So we've just tried to give a flavour, but we are, the 3 of us are here. We're available. You can contact us if you or clients of yours have issues that may need to go into arbitration. Please feel free to get in touch with us. If you'd rather speak in Chinese, speak to Ivy, and or send emails. And we will do our level best to give you some initial insight. Take the opportunity to get some free advice. We'll happily give you some free advice following on from this presentation today, and hopefully persuade you to engage us so that we can start billing you for our legal advice. And also separately, just to say, we have excellent connections with litigation funders, and some of these are very big institutional litigation funders who have several $100 million in funds to spend on appropriate cases. And then we have connections with some smaller or mid-sized litigation funding companies who have an appetite to be a bit more entrepreneurial. So you may have cases in your hands that you think funders may not be interested in. We could tell you very quickly if we think that you have a case that a funder would have an appetite for. So again, please reach out to us and we'll do our best to give you some clear direction. So thank you very much. Ivy.
谢谢这个 Steve。首先要谢谢大家参加这次活动。然后，如果大家有什么问题的话，可以在这个研讨会之后再联系我们。然后我们会很欢迎大家去向我们提问，可以通过邮件，也可以通过微信来联系我。然后，不光是这个法律方面的问题，如果大家是希望我们提供这个诉讼融资方面的资源，就是刚刚在 Steve 的这个演讲里面有提到，就是我们也认识一些能够提供诉讼融资的这种机构。如果大家有这方面的需求的话，也可以联系我们。总之谢谢大家抽空参加我们的活动。也感谢大家就是在百忙之中，然后能够听我们的演讲。如果有什么问题，可以随时联系。谢谢大家。That's it. Yeah. So we can.
Thank you very much.
Thank you very much. Goodbye.
Thank you very much. Bye.